Sarah, are you able to hear me okay?
Yes, Your Honor.
Oh,
Thank
sorry.
you. Miss Sarah, are you there as well?
Yes.
We're on the record in Sarah versus Sarah. This is file number 2311355. The record should reflect both parties are present today. This hearing was set today at the request of Mr. Sarah. Mr. Sarah, what is it that you'd like to state today?
I would like to go ahead and see a final an end to we went through mediation to try to reach an agreement on several topics which you had forwarded to the mediation group, and we did not meet a resolution on any of them. And after talking to the director of the mediation services, she recommended it go to the judge because she could not solve the mediation disagreements.
So what are you asking the court to do?
Make a judgment on several points. The mediator had forwarded to your office her findings, and I'd just like to go over them point by point so we can finally reach a resolution on a lot of these points.
Why don't you tell me what the first point is you'd like to address?
The first point was, let me see, I don't have a printer anymore. I have to look off my screen. It says Jody, Sarah, and Steve Sarah have reached partial agreements on the following. Jody agrees to deliver the 2013 Toyota Highlander vehicle titled to Steve and Sarah, agrees to sign the title immediately to remove his name from the title and mail back to Jody, which I did sign the title. I received it on the end of at the end of January. I have not received any indication from Jody as to whether or not that has been submitted to the SOS to take me off of the title. This has been going on for a couple of years now.
All right, Miss Sarah, have you got that title to give to Mr. Sarah?
Not to give to him. I have the title in my name.
Okay.
Now, part of the resolution was I was to receive proof that I had been removed from the title, which I have received none.
All right, what proof do you want?
Exactly.
For what? Well,
My address, Your Honor, my
Miss Sarah-
address is on.
Miss
All this
Sarah,
paperwork?
hold on. Miss Sarah,
Okay.
we're
Sorry.
gonna do this one at a time. I asked Mr. Sarah a question. I didn't ask you for input. Mr. Sarah, what do you want from her to prove?
I would like a copy of the title or at least a photograph of the title with my name removed, because as of now, I'm still on the title and as such responsible.
Okay, Miss Sarah, can you do that?
It's been done, Your Honor. I have the title in my hand. Problem is, it has my address all over it, and I don't want him to have that.
You can delete that. You can marker that out, or if you have Photoshop, you can easily eliminate your address. I don't care about the address. I just want to see a clean title with my name removed, which I have not, Your Honor.
Sarah, can you send him a copy of that with his name off of it?
Right there, sure.
Next point, Mr. Sarah.
Jody and Stephen both agree that neither are in a position to make payments or pay in full the student loan debt. Stephen
Stephen
agrees
has
to
nothing to do with that.
Okay, Miss
I'm
Sarah,
sorry. Yes,
I'm not gonna keep telling you this.
okay.
Please don't interrupt. When I need a comment from you, I will ask you. Go ahead, Mr. Sarah.
Stephen agrees to try and contact student loan carrier to see if they will take payments from each, Stephen and Jody. I did, and they will not. They expect the loan has actually gone to a collections agency, so it is out of the hands of the student loan debtor, and it's now in a collection agency's hands. And I assume Jody are in the same boat where this is a $250,000 loan. Neither one of us can either make payments or pay off it in full. We each bear half. So as of now, it just stands where it is, I believe. As much as I would like Jody's half of the student payments, I can't make them myself, so I can't. I'm at a quandary on what to do on this. So as far as the mediator goes, this was basically at a standstill, and it's not exactly a negotiation between Sarah and I.
So what are you asking to do about that?
Honestly, I am in no, I don't have the money. They want, for a $250,000 loan, they want twice what I pay on a mortgage. I don't have it.
I
So,
understand that. Well, what are you asking me to do about it?
well, they're threatening to, um, take part of my Social Security. So if they do, which they have not yet, I collect Social Security. They have not yet taken part of that, but if they do, I would like to reduce the amount I would owe to Jody because it's in part of my payment for the student loan. I know this is
Okay.
convoluted and I didn't make sense. I'm sorry.
No, that makes sense, but that hasn't happened yet, right?
No, it has not. It's they just sent me the letter saying they were going to I forgot the legal term, take part of my Social Security payment. And I don't know how much it will be. They did not give me an amount. That is exactly true, sir. The next item was Stephen agrees to owe Jody $2,061 for two vehicle payments in March and April of 25, insurance payments 325 and 425, and a March payment for the pension, which is my part of the pension is 928. I believe Jody receives 933. My question to the court, Your Honor, is for those months of March and April, I was paying $1,000. Uh, Jody did receive a pension for one of those months, but in addition, I'm to make auto and insurance payments, and that adds up to a lot of money that I just don't have, and I don't understand. Maybe the court can explain if I am truly responsible for at the same months I owe auto payments and auto insurance, I'm Miss Sarah's receiving half my pension and $1,000 cashier's check. So she's receiving, I believe, more than she is entitled to for those 2 months. What I would like to see is the two vehicle payments and the insurance payments knocked off. I did pay $1,000 and a per month, which she received, and she did get 1 month's pension payment, which would make me responsible for 1 month's pension payment of 933, depending on if, like I said, I get 928, Jody gets 933. I don't understand. I'll pay her the 933 for the month I owe her, but I would like to see the two vehicle payments and insurance payments seem to be more than I'm owing for those 2 months, and I don't understand.
Well,
I would
this,
like
this
those.
says in the last sentence of that paragraph, this says these funds will be deducted from the payment for the firearms. So those are going to be credited. So it's
Correct.
not an amount you have to pay.
Whatever the court decides, I will abide by.
Well, I'm not deciding anything. I'm just going by what the agreement says. It says you owe that much, and it says these funds will be deducted from the payment for the firearms. So that's money that Miss Sarah is not going to have to pay you for the firearms. That's how that's going to be equalized.
Okay, agreed. The next paragraph, Stephen agrees spousal support of $1,000 per month has been paying regularly from March through April, November 25, which was the last time we had the mediation, I believe. Stephen agrees to continue paying $1,000 per month until Jody is eligible for Social Security, which at this time is scheduled for July of 2026. So I have kept my agreement, and I have been paying $1,000 per month, which I don't believe is contested at this point and is scheduled to end. Jody turned 62 in June of 2026. So that should be my last payment to Miss Sarah.
I will start getting Social Security in August. I'm sorry to interrupt.
All right, Mr. Sarah, what's the next thing? Then that sounds like that's taken care of.
Jody and Stephen agree Jody is receiving the pension directly from the company on a regular basis. And I don't believe that has changed. So Jody is receiving her pension payments directly from the company.
Okay. All right.
It's the next one is there's only two more. Stephen and Jody do not agree on the value of the firearms and would like a determination of those items. Stephen claims the value of the firearms listed on the exhibit are not the current value, but what he paid for them many years ago. Stephen also claims the list is not complete. There were many guns not listed, such as a 1911 pistol. I will add AR-15 was not added. A couple of black powder guns were not listed, although my son has custody of those. I don't have a problem with that. And many assorted BB and pellet guns. Jody claims to not have the guns, but is aware the judge has ruled she is to reimburse Stephen. Now, the last time we were at mediation, she did not agree that she owed me money for these. And that for me is the main outstanding exhibit for today, that Jody is in fact responsible for those firearms that's set forth in the divorce agreement. As far as them being not at the value I would like, I'd like in the divorce agreement, it says she will pay the value of the firearms. That's just a sticking point, whether the value is what that piece of paper, which was for the ATF, was just a registration, and the price I paid for them at time of purchase, and not necessarily the value of those firearms. Although I have not submitted anything to the court otherwise. So Your Honor, I guess I'm asking that Jody agree that she does owe some money for the firearms, whether or not it was the declared value to the ATF or the true value of what they were worth at the time they were stolen.
Well, I'm looking at paragraph 5 of my ruling on the divorce, and that's on page 9 of my ruling from last February. And that says that the court awards to the defendant all the firearms listed in Defendant's Exhibit I, which was admitted by your attorney, Mr. Sarah, during the trial.
Correct.
Which the plaintiff must have returned to him. So number one, that means any firearms that the plaintiff has or has within her control through your son or in any other way, they have to be returned to you. If any of those firearms have been disposed of, or in other words, sold, or just gone and can't be returned to you, then the defendant is entitled to receive the value of those firearms according to the values listed in Defendant's Exhibit I. So I've already made a decision on what those values are, and the values are what they were listed as in your exhibit. So we don't have to decide the question of value because it's going to be according to that. And so Miss Sarah either has to give you those back or she has to pay you those values minus the amounts that you owe her under the mediation agreement for those March and April payments. So those should be deducted from the amount that she has to pay you for any firearms that she can't return. So to me, that answers the question of what needs to happen. And any other firearms that weren't included in your exhibit, that's water under the bridge. That's too late now. That should have been something that was brought up by your lawyer at trial. So, Miss Sarah, I don't know how many of those guns you still have or your son has, but you need to either return those guns to him or pay the amounts that are in that exhibit.
Can I ask a question?
Sure.
How do I return the guns to him safely, keeping me and my son safe, and get him to admit that we gave them to him? Because he told my son could sell them all and keep the money, or he could return them and he would say he never got him. So
where am I about any of that? And I don't, again, as I've told both of you before, my job is to make decisions in this case. It's not about how to give you advice about how to carry out those decisions. So you're an adult, you're fully capable of figuring out a way to return what needs to be returned to him or pay him the money. And so you need to do that.
Can that be done in the court parking lot?
That's not up to me.
All right.
Again, you're both adults, you're fully capable of figuring out how to arrange for that transaction. But that's not part of my job, is to tell you what to do, what not to do. Because I'm not going to be responsible for what you guys do or don't do.
Okay. Can I ask what the total was again?
I don't have that exhibit in front of me, but you should have that in your materials.
Okay.
So that addresses that issue. And I'm gonna give you 60 days to do that, Miss Sarah.
Okay.
Okay. And Mr. Sarah, you said that's the end, the last issue that you have, correct?
There was one more, Your Honor.
Okay.
The last item was Stephen and Jody agree there's still some of Jody's property left in the marital home. Jody agrees to find someone to go to the home for her with boxes, tape, packing materials to retrieve these items. Jody agrees to send Stephen an email regarding the time frame for the pickup. Jody agrees Stephen at least 1 week notice. My only issue with that, and I did give a guidelines for moving document to the mediator, which I know Jody should have gotten a copy to. I believe I copied her on it. Basically said if she can't come up with people to move stuff out, I would pack her items or pack items very carefully and work with her movers under the guidelines for moving. Basically, the guidelines for moving were just basically for my safety and hers and Jody's. I don't expect her to be here. She'll designate movers, and I will go ahead and box up the final items that Jody had left here. My question to the court would be, it's been over 3 years. I agree to return items, but it has been over 3 years that she abandoned this property that I've been taking care of. My question to the court would be, is Jody still entitled to these items? But again, I said I go ahead and return what I can return.
I think if they're her things, yeah, it doesn't matter how much time has gone by. First, they're hers, so she should get them back.
Thank you.
And the agreement is that there's still some of Jody's personal property left in the marital home, and looks like at mediation you agreed to return those things to her. So, and I think this last paragraph in the mediation agreement is a very reasonable method for having that done. So, does that answer your question, Mr. Sarah?
Yes, it does, sir.
Okay. All right. So I'm going to put these things that we've discussed here into an order. I will send that out to the parties. And that's all we have for today. Thank you. You're both.
Plumberg on behalf of Madeline Warren, the plaintiff, who is appearing via Zoom from my office.
And is that Mr. Warren there also or not?
No, that's my client's father.
All right. I don't see him here yet. I'll give him kind of a 5-minute grace period to get here.
Are you going to move on to another matter?
I'm going to see if I've got another party here on that one. So I see Mr. Drebeck is present. So I'll call his matter. Or we'll call the matter of Amanda Seabolt versus Michael Drebeck, file number 16-16242DP. Do we have the parties on that matter present? All right, sir, looks like you're muted. Could you please unmute?
Yes, I'm here, Your Honor. Am I unmuted now?
You are, I can hear you, yes, sir. All right, and sir, you filed a motion, is that correct?
Yes, Your Honor.
And what are you looking to change?
I'm looking to have my support order terminated.
All right.
She
You
no
asking
longer,
for a change in custody and parenting time also or not?
I have no custodial rights or parenting time. She doesn't have custody of him at all anymore.
I pulled the wrong file, so now I'll get myself a little better caught up. All right, so children are not residing with their mother, is that correct?
Correct.
And who is the child residing with?
Technically, it's a family through the foster care in the state of Missouri, in Jackson, Missouri, but it's the state, the 34th Judicial Court of New Madrid is who took.
All right, sir, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, sir, so you currently are paying support for one child, is that correct?
Correct.
The child was living with the mother, but you've been advised that is not happening anymore? And where did you get that information from?
From a caseworker by the name of Classy Lee from the state of Missouri contacted me.
Do you have contact with the child in this case or not?
I do not.
And were you advised as to how long the child has been out of mom's custody?
Yes, I have, Your Honor.
How long has that been?
28 months.
And when did you learn of that?
I learned about this like the end of last year is when the caseworker finally got a hold of me and to let me know. I kind of heard through the grapevine 2 years ago that he was abused and removed, but I couldn't prove anything from that.
All right, well, given Mr. Dravick's sworn testimony regarding this matter, as well as then the mother who was sent notice to appear and failed to appear, I would grant his motion to discontinue these support payments to Ms. Drake or Siebold. Does he have a balance at this time?
There is.
Okay. How far behind is he?
He does have money coming out that's collecting right now. I do not have, his arrears are $1,482.95.
Okay. All right, so I would grant the request going back to the date of his motion, so that would take care of some of that back support. But sir, I can only go back to the date the motion is requested. So you filed it, it looks like December 17th. Any questions from front of the court?
I do not believe so.
Mr. Dravick, any questions?
Yeah, I don't even know how to word the question. So she's been wrongfully collecting support for current child support for 28 months.
Well, you might have some type of civil action, but from the court's ability and perspective, we can only go back to the date that you filed the motion. So we'll discontinue your support beginning that date. She does have a right, obviously, though, to object to anything that I do today. She'll get, well, she might lose that right for not being here, but she will get sent notice of what we're doing here today. But I will discontinue your support as of the date that you filed your motion, okay?
All right. So then what will that mean about the arrearages?
Well, there'll be a new calculation to figure out what your balance should be based on taking away the month of half of December, basically, and January and February will be removed as payments or as requirements to pay. So you'll get a new calculation and your caseworker will let you know what you owe.
All right. Because like even for the month of December, I messed up on my unemployment and I went behind for that month. And then in January, I messed up on the unemployment and went behind again in January. So like, and would the court recommend that I take this as a civil matter to file another motion?
I don't make any recommendations, sir. It's just a potential option that you might have out there to try and address any potential support that was paid to her. All right. Thank you for appearing, sir. The court will prepare that recommended order.
All right. Thank you.
-16351 DP. We have the parties on that matter present.
Martin, Your Honor.
Yes.
All right, thank you. Both parties are present. And Mr. Martin, these are your motions regarding custody, parenting time, and support. Is that correct? All right, so you are muted again. All right, Mr. Martin, if you could please unmute yourself and let me know what you're looking to change.
Oh, there, I got it. Sorry. As of right now, the custody is 50-50. Not legally, but like what we agreed on for parenting time for me and her is 50-50.
Okay.
I was just trying to get so I could have 50-50 legal custody and physical custody.
All right. Ms. Miller, what do you want to say regarding this matter?
I would like to keep it where we're at, 50-50 legal for both me and James. And then for parenting time, week on, week off, Sunday to Sunday, as we have it currently. And share physical custody.
So you're okay with an order that indicates the two of you have joint legal and joint physical custody?
Correct.
All right, and you're doing parenting time week on, week off?
Correct. Yep.
And you guys have a particular day that you exchange?
Sunday,
All right, and you have a time that you guys exchange it?
6 p.m.
How
at
do you guys
M&M. Sorry, go ahead. At M&M at the end of Old State and 27. There's a little spot there we go to.
That's M&M Excavating?
I believe so, yes.
And sir, are you in agreement with those terms?
All but I have been trying to get it because when me and her in the past have contacted each other, it doesn't always end well. So I wanted it to be week on, week off, but Monday pickups and drop offs at school. That way there's limited contact between the two of us.
Ms. Miller, what are your thoughts on exchanges happening on Mondays after school and the receiving parent would just get the child that day?
I would prefer just to keep it to Sunday, it'd be easier on the kids, get them ready for school the next day, they go to school, start the week off that way.
And you said that you guys have been doing Sundays?
Yep, this is our 4th week, I believe. Seems to be going pretty well, I thought.
And sir, you had a motion regarding support also. What is that motion regarding?
She told me she wanted child support, and I already pay child support on one of them. And I have them half the time. I pay for their stuff for school, and I don't think it's fair that either of us would have to pay child support at that point, seeing as how we're equally sharing financial support to them.
All right, so I just discovering, I guess, that there's 2 children in this matter.
Yes, there's
Correct.
2 that are biologically mine, and another one that I have that he's not biologically mine, but he comes with the other 2.
And it looks like maybe there's only an order regarding one of the children so far.
Yes.
Coda, correct.
How old is the other child?
She is 4. James recently, as of December 19th, 2024, was out of the home. We haven't had anything established till now.
But ma'am, you're agreeing that he is the father of that child?
Absolutely.
And sir, you're agreeing that you're the father of that child?
Yes.
So you're asking that support stay the same or be at 0, sir? What?
I mean, if it can stay the same, I'm not, like, I don't know how to, I don't
Well,
feel
it's
we
like-
should have to, but if it has to stay the same, I'd prefer it to stay the same.
There's nothing for Harper though at all. I would like the discretion of in front of the court if at all possible. I've been working with Tara regarding this.
Unless there's an agreement to do something different, the front of the court would do a support recommendation based on the child support guidelines. So parties have the
Perfect.
right to ask the court to deviate to a different amount or to go to 0 if there's no assistance. But if there's no agreement between the parties, the standard is that we run the child support calculation and base the support amount off the support guidelines. So is that what you're asking, ma'am?
Yes, please.
All right, so that leaves us essentially with the issue of the exchange, date and time. I suppose you'd have the right to have a full evidentiary hearing on that issue. I don't know if that's a great use of everyone's resources and times, but
No.
if the 2 of you can't reach an agreement, then I guess that's what the court would have to do. So ma'am, you're asking that it stay as you guys have been doing?
Yes, sir. For the last, I believe it's been the last 4 weeks, 5 weeks now.
All right.
The reason that it stayed at the Sunday, though, is because she told me that I wasn't going to have my kids if I didn't agree with what she was telling me, though.
No, I said it was going to go back to the original time that we did prior to that, not that you
Oh,
weren't
yeah,
gonna have
she
kids
wanted me to
different.
have less time with them because I just wanted the days to switch.
They would just stay the same at that point. We can go back to that schedule if you'd like.
All right, so would you guys like to go to mediation and see if you can resolve your issues, or would you like to have a evidentiary hearing before me?
I've already asked her to go to mediation with me, and she has told me no, that she was taking me to
You can
court
go, I'm
over
more
this.
than willing to.
I've asked you
I
months
wasn't
ago
one, you filed for court, not me.
All right,
because you
so
refused
for both of you,
mediation.
this isn't your opportunity to sit here and just complain to each other, okay? Can we be
Yes.
adults? All right. So you guys are essentially in agreement on everything but an exchange date and time. Like I said, if you guys
Is
can't
there
come
a
to an
different
agreement.
time on Sunday that would work better for you?
Well, if it's going to stay at Sunday, then at least earlier, because by the time I get them back to the house, it's almost bedtime, and it's
You
hard to
want to
get
do
dinner.
4
And
o'clock before dinner?
well, I don't get out of work until 4:30. Oh, it's on
So
Sunday, so yeah,
five?
we can do 4 o'clock.
I think I'm in agreements now.
All right, perfect. All right, Mr. Martin, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
And sir, is it correct that you're asking the court to enter a stipulated order that would grant the parties joint legal and joint physical custody of both children? You would do parenting time on a on-week off schedule, exchanges to take place on Sunday at 4:30, was it? Sundays at 4 p.m. You guys would meet at M&M Excavating. Is that correct, sir?
Yes.
have you guys discussed holiday parenting time at all? Are you following a standard holiday schedule? Are you doing it as the two of you agree?
I would like the standard if at all possible.
That's what we do unless you guys agree to something different. So, sir, are you okay then with holiday pairing time would follow the standard holiday schedule unless the two of you agree otherwise? Meaning you could make some changes if appropriate based on, what's going on with your families. But if there's no agreement, you would follow the standard holiday schedule, which essentially alternates the holidays throughout the years.
That works.
And sir, do you feel this agreement is in the best interest of the children?
Yes.
Thank you. Ms. Miller, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Ms. Miller, are you also asking the court then to enter an order that would grant to the parties joint legal and joint physical custody of the children?
Yes,
Parenting time would be week on, week off, exchanges on Sunday at 4 p.m., meeting at M&M Excavating. Is that correct?
yes,
And you would follow the standard holiday schedule unless you agree to something different. Is that correct?
yes,
And do you believe this agreement is in the best interest of the children?
yes, I do.
Thank you. Friend of the court, were you aware of the issue with the other child?
If we could just get that information, we can make sure that it is added to the docket.
Okay.
And then also if Mr. Martin could please supply his case questionnaire so we can complete the child support review.
All right, so I'll indicate then that you guys need to provide some additional information potentially to the front of the court regarding the additional child. We'll order that child is added to the case. And then Mr. Martin, it sounds like you need to return some forms regarding your employment and income, okay?
Okay.
So return those within 21 days and a new support recommendation will be prepared to address the parenting and custody agreement as well as the additional child. Any questions, Mr. Martin or Ms. Miller?
No,
I
sir.
only have one question, and that is, I've asked her a couple of times what we are going to do with, what is it, taxes and how we're claiming the kids, and she told me she wasn't answering me until we came to court. So I'm just,
All right, Ms. Miller, is there anything you want to say regarding the tax claims in the future?
Yes, sir. I filed like we did every year, just with him not in the households. The agree upon, like we've done every year, was I claim Harper, he claims Coda.
All right. Is that what you want to continue to do, where you claim Harper and he claims Coda?
Yes, sir.
All right, any issue with that, sir?
I was trying to get it so I could claim Harper and Coda because she has two other children that she can claim herself.
Those are my children, though, not yours.
But I
You
also
should claim them.
raised both of them, and I still take care of one of them that comes to my house every week.
All right, so if the parties, so the court itself doesn't determine who gets the tax exemption. So if the parties have an agreement, we can make it a part of an order. If the parties don't have an agreement, then the IRS rules are what control. The IRS rules say whoever has the child the most overnights gets to claim the child. So obviously it gets sticky when there's a week on, week off, because you got to get down to the nitty gritty if you don't have an agreement and figure out who had the most overnights in that year.
It wasn't for
Typically, when-
2024. That's why I filed already.
Typically,
It was-
when parties have every other week with a child with multiple children, they agree to one claim one claim the other, which is usually the resolution. Otherwise, you're going to have to track your overnights and you might get into some fights when it comes down to tax time. So usually the simple thing to do is you alternate, one claims the other when you have two children together. So you guys can either make that your agreement or you can address it at tax time and see if you run into issues with claiming. So Ms. Miller's proposed that she claims one child and you claim the other child. Are you in agreement with that, sir?
Yeah.
Okay. So I'll also indicate that the parties agree that Ms. Miller will claim Harper for tax purposes and Mr. Martin will claim Coda.
Correct,
And that includes the 25 tax season, so last year.
correct.
All right, so for 2025 and moving forward, the parties have that agreement also. All right, anything
Thank you.
else?
No, sir.
You did get muted again, Mr. Martin.
I have paid child support on Coda since he was 6 months old. And me and her just split up a year ago. We lived together. I was in the house with Coda his whole life,
For
but
the
I was
expenses.
forced to pay child support that whole time.
Well, what you have to do, you have to file a motion when that happens and address it. So I can't go back in time. I can only go back to a date you filed the motion, and it sounds like at this time you were already out of the house. So I can't go back in time and change things unless there was a motion filed during that time frame. All right, thank you both for appearing. You're all set. You will get a copy of the court's recommended order or your stipulated
you.
order. Thank you.
Hearings like these show how family courts adjust orders when circumstances change. Whether it's a child living in a different placement or parents shifting to a shared schedule, the court's role is to update support and custody arrangements so they match the current reality. Even when parents already have informal agreements in place, the court often formalizes those terms to create clear expectations moving forward. If you appreciate real courtroom breakdowns explained in plain language, be sure to subscribe to the channel so you don't miss future cases.